Hi, and welcome to Holland Estates. You're listening to episode number 641. It's June 2020. How are you, Artur?
I'm doing well, thanks, Paul. How's your day going?
Great so far. Great day. And even better now because we just had a very interesting discussion off the record about this case that we've come across. And we're going to see if we could have some of that recorded now and just to get the knowledge of this case out to everyone and the awareness of the issues there and maybe a further discussion on the implications. So today we're going to talk about a decision. It's in the matter of the estate of Linda Weinrib. It's a decision of Justice Kimmel, released March 29, 2022, and it deals with the effects of a pour-over clause. And maybe we can talk a bit about what the will said, what a pour-over clause is, and what the effect in Ontario or the validity is with respect to a pour-over clause. So maybe you can tell us a bit about what a pour-over clause is and does.
Absolutely. So essentially, a pour-over clause pours over the residue of the estate into to the trustees of a trust, and there seems to be a bit of uncertainty about the future of it in Ontario.
Right. So in this case, the deceased had a will that said that the residue of her estate would pass to the trustees of her alter ego trust. The trust was in existence. It was created at or about the time the will was made. And to simplify the administration of her estate, she simply had all of her assets that remained in her estate go into her trust to be dealt with there. And the question became whether that was a valid clause in a will. The case dealt with a few other issues. One was an issue with respect to a lost will. They didn't have the original, but they had a copy. All of the beneficiaries consented to proof of the copy of the will being proved. So that went on without opposition. There was an issue with respect to whether a condo that went to one of the beneficiaries by right of survivorship was an actual gift to that beneficiary, or whether it was held in trust for the benefit of the estate. That was dealt with on consent because all of the parties agreed on how it was to be dealt with. But the court was and Justice Kimmel was very appreciative that the matter went before her because there was this issue of the pour-over clause and whether it was valid or not. The estate trustee looked into the question and found there was competing case law, and therefore sought the opinion and directions of the court, even though it wasn't opposed and nobody objected to the money going in accordance with the pour-over clause. However, just for the sense of propriety, the estate trustee asked the court to determine whether the pour-over clause was valid. And maybe we can talk a bit about the competing case law outside of Ontario and what it found and what the Ontario court did.
Yeah, so the two competing authorities for pour-over clauses come from British Columbia and Nova Scotia. And so I guess the two approaches take completely different paths in validating or invalidating pour-over clauses. In BC, they decided that pour-over clauses would be invalid. And the reason for that is because the court has focused on formal requirements for executing wills. The court in BC, British Columbia Court of Appeal, the case is Quinn Estate, found two problems with pour-over clauses. Number one, the court said that, if you're going to have residue of the estate going to a trust, that trust is amendable and revocable. That, should not be done without regard to the BC Wills Act formalities. In a sense, it allows the testator to make a disposition in the future without complying with the formalities of the BC Wills Act. And the second problem, related problem that BC Court of Appeal had with it was that it creates uncertainty. So because the trust is amendable, it cannot be known for certain that the actual disposition to be made by the testator is governed by the terms that are not found in the will itself. And so, in fact, there was later a lower level court decision in BC, and the parties try to distinguish from the Court of Appeal. And in that case, the trust was not amended after the execution. The case is Waslinchuk Estate. And in that case, court again refused to distinguish, and the court said that the decision in British Columbia Court of Appeal in Quinn turns on whether the pour-over clause is to an amendable or revocable trust. It's the possibility of the amendment or revocation once the disposition, has poured over into the trust, that is at the core issue. It doesn't matter that the trust was actually revoked or amended after will was executed. It was invalid. And do you want to talk about the Nova Scotia approach, Paul?
Right. In the Nova Scotia approach, they took a step back from that BC approach, and they looked at whether there was an actual amendment to the trust after the terms of the will. So if there wasn't, then the pour-over clause would be allowed to stand. So they took a more perhaps a more practical and not strictly black letter law approach to it. If they I guess the concern that you addressed is that I make a will and I put everything into this trust. I can change who the beneficiaries of the trust are without the formal requirements of making a will. I can just make an amendment to a trust agreement without witnesses, without due execution. And in Nova Scotia, they will look to see whether that trust has been changed at all after the date of making the will. The court in Ontario preferred the BC approach, and therefore the decision is that if the pour-over clause into an amended or amendable or revocable will not be effective.
Our Ontario court actually went a step further, and they criticized the Nova Scotia decision for, the judge said the formalities are there to prevent abuses, and loosening of these restrictions after the fact does not serve the intended objectives of the formalities, is what the court said. And they were concerned that the reasoning of the Nova Scotia approach was influenced by a view that a strict execution of the requirements do not need to be enforced in situations here policy concerns underlying them that do not actually arise. So those are the words in the decision. Right.
And it's not odd that it was applied here, but we did have strict compliance with respect to the formal requirements of making a will. That's been relaxed now with new legislation that says that strict compliance is not required, and you can have substantial compliance and have the terms of a will proved, even if there is not strict compliance. Having said that, though, the court here decided to apply the BC law and look at the pour-over clause. If it's to an amendable or revocable trust, then that's not going to work, unfortunately. Now, the effect in this case was that the money that was supposed to go into the trust didn't go into the trust, and it passed on intestacy. The court noted that all of the beneficiaries were in agreement that the money would be dealt with as if it was in the trust. And therefore, the court said, so that there's no harm, no foul here. The beneficiaries, the intestate beneficiaries who received it, could put the money into the trust and have it dealt with that way. So that might have influenced the decision in a way, but I don't think that's a reason for the decision or a distinguishing ground. I think that was just a fortunate outcome in this case.
Indeed, it was. So what do you think, Paul? Do you think this decision creates any kind of estate planning issues or things to think about for state solicitors or people wanting to set up a pour-over clause in Ontario?
Yeah, I think that it raises a real issue. I don't think you can do it unless you are dealing with a trust that is not revocable or not amendable. If you are going to have money poured over and then there's a clause like that in your will, I think you need to review that now and consider an alternate. Give it to someone else who can then settle it in the trust, or replicate the terms of the trust in your will, so that you are establishing a trust under your will, that it's in your will and not some outside extraneous document. So I think that's a real concern. And I think that's, it's going to cause all of us to look at our wills to make sure we don't have that type of a clause in it. And I think that, in the Henson Trust ODSP context, a lot of people have inter vivos trusts set up for children or grandchildren, grandparents in their wills when they leave a part of their estate to disabled child or grandchild, they often will put the money into that trust, and that may cause problems. It may fail in this case, in that case, because of the implications of this Weinrib decision. Well, I think that needs to be reestablished.
I have another question for you, Paul. So you know how in the BC there was a trial level decision that tried to distinguish from the Court of Appeal because the trust was not revoked, it was not amended, right, and the court refused to distinguish. Do you think there is a possibility of a similar challenge in Ontario, given that our decision is a trial level decision? It's not a court of appeal level decision. Maybe someone else trying to distinguish and try to set a new precedent for.
Yeah, I think that, you know, there's always the option or opening for a different decision. This case could have gone either way, and there may be reason for saying that if I'm putting money in, you know, paying if my estate is passing pursuant to, you know, a memorandum or a document that exists prior to the will, I can do that. If it's amended, that may be offside of the Succession Law Reform Act after I make the will. But if it's not amended and the money is passing in accordance with the terms of my will and the document that pre-existed, you know, I can see a court saying that may be permissible. And the test should be not whether it was amendable, but whether it was in fact amended. If it wasn't amended, then all the formalities have been complied with. So I can see there being, you know, the basis for a competing decision there, and that's something the Court of Appeal would have to weigh in on if that ever came up. I do note that, you know, this decision came out in 2022, and the court noted that it never was an issue that was raised before in Ontario, and that's why they had to deal with it here, because there is no case law in Ontario. So I'm not sure if and when another decision like this will come up, but if there will be a competing decision. But clearly, that's something that the Court of Appeal would have to weigh in on if it went the other way.
Seems to go under the radar, this decision. There's very not many alarms were rang for you know, raising nobody really raised an alarm about this, but it seems to be that pourover clauses are essentially invalid in Ontario.
Yeah, and I think that they are probably more prevalent than people expect or, you know, believe, because people do put a lot of time and work into creating trusts, and it's an easy mechanism to have your will just say everything will go into the trust that I spent so much time, effort, and money on creating, and to deal with my estate that way. I think that brings us to the end of this discussion, and I want to thank you, Artur, and thank you to our listeners or watchers for following us again. If you have any questions, please visit our website and post a comment or ask a question, and we'll be sure to get back to you.
Have a good day, everyone, and please review your will if you have a pourover clause.
Excellent advice. Thank you.